My name is Yelda Bartlett. I'm an attorney practicing in California for the last 10 years, and I practice in the area of family law, which includes divorce and child custody and adoptions. Generally, yes. Fourth degrees from other states or countries will be recognized in the United States by operation of a doctrine called international comity, which requires mutual recognition of judicial acts. So as long as the foreign decree was issued as a result of a fair and impartial process in the foreign jurisdiction, giving proper notice and opportunity to respond to the parties, then the reviewing court in the United States typically will have the authority to enforce the judgment. For example, let's say Yoko Ono and John Lennon divorced in Japan, and now so for example, let's say Yoko Ono and John Lennon divorced in Japan, and now Yoko lives in California. Under California law, Yoko and John will be considered divorced. They can remarry and file taxes as single persons. No additional legal action is needed to make their Japanese divorce valid in California. Let's say the Japanese decree gave custody of the minor child to Yoko, but was silent on the issue of child support. If Yoko is living in California, she can ask the California court to order child support, even though the Japanese court was silent on that issue. In contrast, let's say Janet Jackson was divorced by her husband, Wissam Almana, who's a Qatari resident. That divorce will also be recognized as long as notice and due process requirements were met and can be enforced by a court in Janet's home state. But let's say Wissam obtained sole custody of the minor child under Qatari law only because Janet was a non-Muslim. The court in California may say that that is fundamentally unfair and violates Janet's civil rights. So they would decide that issue de novo, which means completely anew. And as long as the child is within the state's borders, the judge can make an order as to that child. If one spouse resides in the United States and the other is abroad, either of the spouses can file for divorce in the U.S. state where the other spouse resides. After filing of the divorce, the non-party has to be served with a petition and summons, but this is where things get a little bit tricky. If the matter is uncontested, if the parties agree to the divorce, they may be able to agree to have the party who's abroad receive the service of documents via mail, and they can sign a notice and acknowledgement of receipt saying that they received the mail. After that, the spouse in the U.S. Can proceed with in the U.S. court. But if the matter is contested, then the rules governing the service of these documents is governed by the Hague Convention, which requires two expensive and time-consuming things. First, the translation of court documents into the local language, and two, the delivery of the documents to a designated central authority in the country, who will then complete service of the papers to the other party. Depending on the country, there may be a large fee associated with the service, up to $1,000 or more, and may take up to even a year to complete service. The rules for the Hague Convention really depends from country to country, and some countries it's a lot easier than other countries, so you should contact a lawyer in your jurisdiction to determine which rules apply. You do not have to file a divorce in the state that you're married in, but it really depends what the rules are, depends on which state you live in. So, for example, in Nevada, you can file a divorce there if you have been married there, or if you have last cohabited there, or if one of the parties lives there. In California, at least one of the parties has to reside in the state for a minimum of 6 months. Another issue that comes up with residents when we're talking about filing for divorce is what happens when two parties live in different states. In this case, either of the courts in the different states, if you live in, one party lives in Nevada, the other one lives in California, either one of them can file in their home state, but then whoever files first gets to select the state in which the divorce will be adjudicated. Yes, the U.S. Constitution requires it. A state is prevented from treating citizens of other states in a discriminatory manner. So that means orders and judgments from other states have to be recognized in the United States. Yes, a person can file for divorce in any U.S. state as long as one of the spouses reside there. Some states like California, like I said, it requires that the spouse has to live there in a minimum of 6 months. Other states like Nevada have a 6-week residency requirement and some other requirements. So because the rules vary from state to state, be sure to consult an attorney within your state for more up-to-date and accurate information. In California and most other states, you don't need to provide your marriage license to obtain a divorce under ordinary circumstances. But let's say your spouse disputes that you even were married and your spouse saying that you weren't married at all. Then you're going to need your marriage license to prove as a part of the evidence that you're going to present that you were in fact married. So if your marriage license was destroyed, you may have to obtain a copy of the license from that entity.